are back, and we are joined by the great Elie Mystal, justice correspondent, columnist at The Nation, and Alfred Nobler Fellow at the Type Media Center. Elie, thanks so much for coming on the show.
Hi, thanks for having me. Sorry, my dog is being annoying, so we're just gonna have to deal with it.
Not being annoying to me. I would like to know a name, and I would like to see a face.
Oh, it's Cassandra. She, like me, she sees the future, but nobody believes her.
Oh, so she's a leftist. It's about being right too early.
That's right.
All right. Anyway. Well, good to know that she's a comrade. Well, we'll get right into it here, Elie, because I'd covered this a few weeks ago prior to the oral arguments, but the oral arguments were last week. The Supreme Court heard arguments in Louisiana versus Calais, which is basically centered around Section 2 of the Voting Rights Act. But maybe let's just back up really quickly to speak about how the Supreme Court in recent years has already gutted the Voting Rights Act, to give us some context as to where we are with this case.
Yeah, so Emma, it really goes back to John Roberts. People need to understand that John Roberts has made his entire career to oppose the Voting Rights Act and oppose the equality in voting. He's got his start as a Reagan lawyer arguing against the expansion of the Voting Rights Act back in the 1980s. Now, he lost that fight because the Voting Rights Act used to be a bipartisan issue. Even Republicans realized that they couldn't be so openly racist to the concept of a full and equal government. But then he got onto the Supreme Court. And for the past 20 years, this year is his 20th year as Chief Justice, he has been a consistent enemy of the Voting Rights Act and has done everything in his power to take it down. This case last week is just the latest example of that. But there's a long history here with Roberts and his opposition to Black voting rights. I've argued that Roberts has been the biggest enemy to Black people and their equality in this country since Chief Justice Roger Taney, who authored the Dred Scott decision and famously said that a Black man has no rights the white man is bound to respect. Roberts is that guy updated for the modern age. People think, oh, it's Sam Alito because Sam Alito is always running around with his flag hanging out of his pants or whatever. And I get that. And Roberts is a more genteel version of it. But make no mistake, Roberts is the guy, in the Matrix kind of tautology. He is the guy guarding every door and holding every key, preventing Black people from voting equally and fairly in this country.
And the previous attacks on the Voting Rights Act are in many ways why we are where we are today, basically, because it made it easier to undercut the law when essentially the premise from the Supreme Court in previous cases, if you don't mind explaining this a bit, was just like, it's been enough time. It's been racism's kind of done, so it's been enough time. We don't need this anymore.
Yeah, I argue that you can draw a direct line from John Roberts gutting the Voting Rights Act in 2013 in Shelby County v. Holder through the election of Donald Trump and our current eruption of white supremacist fashion. There is a linear progression from what Roberts did in 2013 to where we are now. And Emma, you're exactly right. The core argument from Roberts and other conservatives has been racism has been solved. That we are beyond this, that we don't have to continue to worry about protecting Black voting rights because white people are over their racism, and it fails. That argument fails every time. It never survives its first contact with reality. I like to think of it. I like to use the Ruth Bader Ginsburg phrase that throwing out things like the Voting Rights Act is like throwing away your umbrella in a rainstorm because you're not getting wet yet. Like that's kind of what the conservatives want us to do, the Republicans want us to do, because these laws and these policies have been effective. They say that we don't need to use them anymore. And to get to the current case, that came up directly in oral arguments in this voting rights case that happened last week, where Brett Kavanaugh essentially argued that we don't need Section 2 of the Voting Rights Act anymore because white people are over their racism, that there should be a sunset provision to the Voting Rights Act, which was a wild thing for Brett Kavanaugh to say, because Congress passed the Voting Rights Act and did not put in a sunset provision. They did not put in a time limit when they passed the 1965 Voting Rights Act. They do for other laws. There are laws that Congress passes with what's called a sunset provision, where they say after a certain amount of time, if it's not reauthorized, then this law lapses. Like, that is a thing Congress does all the time. Not with the Voting Rights Act. So Brett Kavanaugh saying, like, well, there should be a sunset. Well, that's great that you think so, Brett, but nobody elected you to make that call, right? You're not in the legislative branch. You're in the judicial branch. You're supposed to follow the law. And this law has no sunset provision. But Brett Kavanaugh, like John Roberts before him, they always want to say that, oh, racism is over, and so we don't have to be concerned about voting rights anymore. It is how conservatives win. It's how Republicans win. Because if you don't protect the Voting Rights Act, if you don't protect the ability of Black people to vote, there's no version of events where the Democratic Party wins. And that's hard for Democrats, I think, sometimes to get their minds around. But there's no version of events where the Democrats exist as a national party without robust support from Black and brown individuals.
And the estimates about if they rule to overturn Section 2 of the Voting Rights Act, in this case, about the amount of seats that Republicans could add, essentially eliminating Democratic representation in southern states, it's up to 19 that they could add.
So to get into the specifics of the case involves a Louisiana congressional map that was initially made with 5 majority white districts and 1 majority minority district. Now, that makes no mathematical sense. Louisiana is 56% white, not 83% white. In fact, Louisiana is 30% Black. So again, simple math would tell you if you have third of the population, you should probably have a third of the congressional districts, which means you should have 2 majority minority districts, not just 1. So a court under the Voting Rights Act ordered Louisiana to draw a second map with 2 majority minority districts. They did so. And that is the map that got challenged and is up at the Supreme Court right now because white voters in Louisiana argued that the second majority minority district violated their constitutional rights to equal protection. White people in Louisiana are literally arguing that they have a constitutional right to be overrepresented in Congress, to have more representation than their population would allow as a constitutional principle. And that's the case that went up to the Supreme Court. Specifically, what stopped Louisiana's initial racist map was Section 2 of the Voting Rights Act, which critically does not look at intent, right? In other sections of the law, other sections of the act, you have to prove, that somebody tried to be racist. Section 2 does not. Section 2 looks only at outcomes. So Louisiana can run around and say, I don't have a racist bone in my body, and I have lots of Black friends, or whatever they want to say. It doesn't matter. If the outcome of your map is racist, then Section 2 of the Voting Rights Act is allowed to operate. And that core is what the Republicans want to take away. They want to change the analysis so that you have to show intent to be racist in order to for the Voting Rights Act to operate. And obviously, Emma, I mean, I don't think I'm speaking out of school here to say that for the most part, white people don't admit to being racist. They don't confess to being racist. There's always some other reason that they're doing these racist things, right? And so you're never going to get that kind of proof, that kind of as Janae Nelson, who argued the case for the NAACP Legal Defense Fund, put it, you're never going to get that confession or admission of racism. They're always going to say, oh, we had some other reason.
I mean, I'm often bringing up the genocide in Gaza just when I can, but like it reminds me of the arguments about saying it can't be a genocide because they didn't write I am committing genocide on some sort of paper. Like they're not going to admit that. I mean, this is part of how it works, at least in terms of like what's been written down, which is also why, I mean, I want to continue to stay on this case, but just emphasizing how impactful Shelby is. that case from 2013, which destroyed Section 4 of the Voting Rights Act, which required basically pre-clearance from these southern states, from the federal government, when they were creating their congressional maps. It almost appears like they decided that case so that they could do what they're doing now, this like ad hoc determination. Because as you write in your piece, their arguments, or if they rule the way they're indicating in their oral arguments, it is completely contradictory to their own precedent in the 2023 case, Allen versus Michigan, where they sided the right way against a racist Alabama map. I don't understand how you can side with these white plaintiffs who are arguing basically reverse racism in Louisiana and have sided in the exact opposite way in Allen v. Milligan, because the facts are almost identical here.
The cases are almost a carbon copy of each other, but what's different is the lawyering. And people had said at the time when Allen v. Milligan came out, because it was a decision that upheld the Voting Rights Act and upheld the forcing Alabama to create a majority-minority district, which was surprising from these conservatives, Roberts and Kavanaugh joining the liberals to uphold the Voting Rights Act. That's, again, that is unusual for these guys. So why was it? Well, Alabama lawyered their case, I think, particularly bad. As I said, Roberts likes to pretend that racism doesn't exist unless people show up in his courtroom and are like, I'm doing some racism today, right? Like, then Roberts is like, well, and so this idea of like, do white people have to confess to being racist? In Allen v. Milligan, they kind of were, right? They got as close as you possibly come to a confession of racism. The way they argued and lawyered their case was not that, oh, Alabama is in compliance with the Voting Rights Act. They said, oh, we don't have to be in compliance with the Voting Rights Act because the Voting Rights Act is stupid. And that, I think, was the bridge too far for Roberts and Kavanaugh, right? In the Louisiana case, Louisiana is saying, no, we're still complying with the Voting Rights Act, even if we only have one majority-minority district, for reasons. They're terrible reasons, they're bad faith reasons, they're incredible reasons, but they're giving reasons why they can still be seen in compliance with the Voting Rights Act. They're saying, we're not trying to be racist. The lawyer representing Louisiana literally said, and this honestly made me laugh out loud before I started crying, if the Louisiana would have drawn the exact same map in the exact same way, even if the races were reversed, right? That their goal was to discriminate against Democratic voters, not discriminate against Black voters. Now, that argument is another Roberts special that comes to us from John Roberts in a 2019 case now called Rucho v. Common Cause, where Roberts said that political gerrymandering was okay. That as long as you're only discriminating to protect Republican incumbents, you're good, right? And so Louisiana is saying we were only trying to protect Republican incumbents. But here's the thing, Emma. Again, we have math here to on our side to like understand things better, right? And the math says in Louisiana in particular, but generally across the South, that white voters, white Democratic voters, won't vote for a Black candidate even if it's in the same party, right? The numbers say that white Democrats in the South would rather vote for a white Republican than a Black Democrat. That is a statistical reality, right? So if you are going to have Black representation in Congress, you literally kind of need majority-minority districts because white people won't do anything better. Like, white people won't go for it, even if you're talking about a person of color from their own party. That's the reality here that the Voting Rights Act is trying to, again, correct. And that's the reality that Roberts and Kavanaugh won't let happen.
Well, I mean, it's also just so pathetic to have an argument which is basically, trust me, bro, being enough to flatter the the Chief Justice of the Supreme Court to get him to do what he already wanted to do. It's just, there's no evidence to support this claim. I'm not even, can you give me some insight into what the legal arguments are that would support their "trust me, bro, it's not racist" thing?
It's their own testimony. They're promising you
But that's
that
it. That's all they're providing to the court to support their claim.
Roberts is saying that's all they need, right? Like Roberts is saying that's all they need. Roberts is saying that if you can show that you are trying to discriminate against Democrats and not discriminate against black people by the way that they drew their map, by the initial 5-1 map that was just protecting Republicans. Whereas when you draw the 2 majority-minority district map, I mean, this came up a lot with Alito because he was saying, well, the districts are not compact, right? That we want districts that are close together. To get your 2 majority-minority district, you have to kind of split Louisiana kind of down the center. You have to kind of diagonally go across the state. There's like a black belt in Louisiana where black people live. So you make 2 districts in a kind of diagonal line. That's how you do it. And that doesn't look pretty to Sam Alito. I mean, his argument was that it wasn't, who cares the fact that the white districts are also all oddly shaped and weird. No, we don't care about that. We only care about the fact that the black districts look weird to Sam. And that's apparently enough to kill the Voting Rights Act. And again, as you've brought up a couple of times, if they rule this way, that immediately flips 1 seat from Democrat to Republican, right? Like if you go back to the 5-1 map, that's taking 1 black seat out of Congress and putting it back in the white corner, and most likely that's going to be a white Republican who wins that seat, right? Some analysts have said that if states can gerrymander fast enough after they release this decision, and we don't know when they'll release this decision, but if they're certainly going to release it before the midterms. And if states can move fast enough, some analysts say that as many as 19 seats across the South could be in jeopardy, right? I mean, you're talking about majority minority districts. You're talking basically about the Congressional Black Caucus, and this case kills it. I mean, like it's designed to kill the ability of black people to be represented in Congress, and that has huge implications on the upcoming midterms. So in addition to their legal strategy here, people need to understand the political strategy from the Republicans on the Supreme Court, because let's be fair, they are politicians in robes. They are Republicans on the Supreme Court. There's a direct electoral strategy here. All of this talk that we have about gerrymandering and Republicans trying to protect themselves in the midterms, this one case can flip the whole thing.
So in theory, does this give, say, California passes the prop, which I'm forgetting the exact, is it 80? Prop 80? In the ballot referendum in the measure, does that in theory give them the ability to eliminate Republican districts from their maps?
California's already trying that, right? And they don't need this case to do that. That's under, again, the 2019 Rucho v. Common Cause decision. California, according to Roberts, is allowed to gerrymander its state as much as it wants to discriminate against Republicans. What's stripping up California is its own state
Prop 50. I just want to correct myself. Thank you.
Is its own state law processes. That's why you have a voter referendum, because you need to change the state law. In New York, where I live, and I looked into this like pretty hard, you kind of can't change New York state law, certainly not in time for the 2026 midterms. There's a chance, there's a possibility that you could change it in time for 2028, but that's not a Supreme Court issue. That's a function of New York state law and New York's state constitution. One of the problems, and I think I've talked about this on the show before, one of the problems that we have is that we don't have one federal electoral system. We've got 50. Each state is generally allowed to do its own thing, and it becomes a race to the bottom, right? When Texas decides to drop their drawers and show their ass, that almost forces Illinois to do the same thing, which then requires Tennessee and Florida to do something stupid, which then makes California also go to the bottom. And then New York is trying to catch up. Like it's a race to the bottom, because if political gerrymandering is the rule of the day, then if you are in charge of a state house, you are stupid. You are committing political malpractice. You are hurting the country if you don't gerrymander your state as much as possible using whatever means, to quote Louis Gossett Jr., fair or unfair, to get what you want, right? Like that's where we're going.
Well, I mean, the Voting Rights Act was necessary but insufficient even in what we're talking about here. Like there should have been, frankly, an effort by Democrats to say, this is where we build off of things like the Voting Rights Act, or at the very least try to codify something stronger, because without some movement towards like a standardized process of, say, proportional representation, this kind of game is going to continue to get played. And we know that they have money, they have capital, and they've got the white supremacists on their side.
Yeah, it's look, the Democrats tried to restore the Voting Rights Act in 2021 after both of these decisions that we keep talking about, Shelby County and the Rucho decision. They tried that bill, that first Senate bill was scuttled by Manchin and Sinema. It was scuttled by Manchin and Sinema, and it was scuttled by the Democrats' own refusal to break the filibuster. But they tried, arguably. Look, I don't know what else you could have done to Manchin. I don't know what else you could have done to Sinema. I would have kidnapped their dogs. I mean, like I would have gone the full Monty to get them on board. But I don't, they voted against it. Manchin and Sinema would not let us restore the Voting Rights Act when we had a chance in 2021. And now this is a time of consequences. Now we are living with that failure, that inaction, and this is what you get. The Republicans understand. Look, I always say that it's an electoral strategy, but I understand the brass tacks here. Republicans understand that if everybody who wants to vote can vote and has their vote counted, Republicans can't win. Republicans understand that they are the unpopular party, that they are the minority party, that they can't achieve their goals through free and fair elections. And so their response to that is almost rational self-interest to do everything they can to sully and muddy elections. The problem is that Democrats don't seem to have the same focus. Like they don't seem to have the same focus on protecting voting rights when they have the chance, knowing full well the Republicans are going to do everything they can to take away voting rights when they have the chance. And that is the asymmetry in the battle we're fighting. Democrats understand it is in their political advantage if everybody votes. It's in their political advantage to have high turnouts, but they don't do the things that we need to do in order to have everybody voting and to have high turnouts. Like that's the core of the problem here, and I don't see it getting solved anytime soon.
Hey folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.